The problem asks you to look at estate of Samuelson. Again, I always kind of poll students. Some people actually look at a case when it's named in a problem. Anybody look at the case? Okay, fair enough. I never used to either. Okay, so common law. Common law was with no spouse, descendants, or parents. We know that siblings will take. We're going to look at that a little bit more next week, okay, or the week thereafter. Thus, A and B would get the entire estate. If B is disinherited, okay, then B is treated as having predeceased T. And states are going to vary, okay? Some states, although not many, are going to say if you disinherit B, everything goes to A. But other states, and the UPC's approach, is that if B is treated as predeceasing, right, because in effect you've taken him out of the will, his share can pass to X and Y. So that's what the Samuelson case talks about, okay? Because T did not say, I also want to disinherit my nieces and nephews, they're just going to disinherit B, treat B as predeceasing, and let B's share, the half, go down to X and Y. That's the UPC approach. Just going, and why is that the UPC approach? Because if we treat T as predeceasing under the state law, right, then we have a partial intestacy. And the intestate laws would say that your siblings, as we're going to look at, siblings will take per stirpes as well, meaning if one of them predeceases you, their children step into their share. Okay, questions on that? We're going to talk a little bit more about that when we get to topic 6 and look at collaterals, which is, remember, we focused on surviving spouses and children pretty much up to this point. Okay, we're going to continue with children, and then we're going to pick up and look at siblings, and what we call collaterals, siblings, nieces, nephews, cousins, etc. Any questions? Okay. That's it on the per stirpes issue. Okay? So let's move on to children. Yeah.
When you said, when you were doing the UPC example where F would predecease and D, H, and I would all get 2 nines, where did the 2 nines come from? I was just confused. Like.
Oh, okay. So maybe the easiest way is to take another marker. Let's see if this works. Let's take F out. Not take him out, but take him out of the equation, right?
So
okay.
Like, you go to the first line like you do.
Right. So in that situation, under modern, all this stays the same, right? Yeah. Modern, even UPC, D stays the same. F's under modern, I gets the 1/3. Okay? But under UPC, you take E's 1/3 and F's 1/3, undistributed, the 2/3, and divide it equally at the next generation, G, H, and I. So under that situation, we would have each getting 1/3 of 2/3, or 2 ninths.
So you take E and F's portion.
Correct.
See how this is confusing?
It is confusing, right? So that's the only real difference between modern and UPC, is that if you have more than one predeceased person with heirs, you take their shares and then the next generation shares equally. So I mean, if I were to add this down here, I'll write it just next to it. You get the 2 ninths if we take F out of the equation. Good. Any other questions? Okay. Let's talk about children. Person who's taping this, is this on?
Yes.
It is on. Okay, good. They're seeing a little bit of me walk back and forth, so that's good. Okay. We'll wait for. It's coming on. Okay. Give it a second. So we're going to start off talking about adopted children. Okay? And here's the basics on adopted children. An adoption, as I put in that very first line, is considered a rebirth. I'm just a comedy show up here. Okay. I should have spiked my coffee this morning. Okay. So take a typical situation, okay? A young unmarried woman gets pregnant, decides to keep the child but give the child up for adoption. Okay? Should she be considered the child's parent in later years for purposes of intestate succession? And the answer is, if the child is adopted, no. Okay? Generally speaking, adoption severs the parent-child relationship between the what we call genetic parents under the UPC. Sometimes you hear the word natural parents. It severs the relationship, the parent-child relationship. And thus, there is no relationship under the law once the adoption becomes effective, meaning they're no longer deemed to be a child of yours for intestate succession purposes. Okay? So adoption is really an entirely creature of statute. Okay? A statute. So we're not looking at common law as much, although we're going to have a couple common law concepts in here. The treatment of adopted children is subject to that general maxim that the right to receive property is not a natural right, but a privilege. So remember, generally speaking, going back to our first topic, you have no right to inherit. Okay? Only surviving spouses, as we've discussed, have a right to receive something. Children do not. Okay? With a few exceptions we're going to look at as we go along. Okay? The state has the power not only to regulate the manner, but also the persons who can receive property at death. And that's going back to our discussion in Hodel versus Irving. You know, you have a right to convey, but not a right to receive. We're going back to that. That is why adoption is mostly a creature of statutes, because we are, in a sense, legislating that in those instances, adopted children are going to have certain rights. Okay? So the first case you had to deal with was the Hall case out of Maryland. And what's going on here is states kind of struggling for a while until we started, this is 88, so we did have Uniform Parentage Act in place and other things. But states are still going to have some quirks as to how they deal with children and inheriting from both adopted and sometimes not, and sometimes they're natural families. Okay, so anybody want to volunteer, since I don't even have my seating chart, that's going to work, to talk a little bit about what's going on in the Hall case? Yes, thank you.
So Paul passes away,
Okay.
And his wife remarries, and they have 4 kids. The wife remarries, and the husband adopts the 4 children.
Okay.
After all that happens, the original, the children's genetic father passes away, and the children's genetic father's brother passes away.
Okay.
And they claim to have an intestate right to their uncle's estate. And essentially, what ends up happening is that the court puts that rule forward that they claim that they have this inherent right, that it's a natural right. The state says no, it's a creature of statute, like you said.
Okay.
And they say that once a child is adopted, the rights of the natural parents or relatives terminate.
Okay. Good. And so what they're saying is, unfortunately in this situation, or fortunately, whatever you want to look at it, these 4 children cannot inherit from their genetic uncle. Okay? Because the adoption by their now stepfather, okay, severed their relationship with their genetic father's family. Okay? A little complicated. And the reason this is a case, and you're thinking, okay, well, that's what you just said, why is the case there? The case is there because the old Maryland law allowed dual inheritance. So go back to the 60s, where a lot of states had kind of not modernized their thinking on this issue. They allow dual inheritance from both natural relatives or genetic relatives and adopted relatives. At least in Maryland, that law was repealed in '63, and now Maryland, like a lot of states, severs all rights of inheritance from the genetic relatives. Okay? And to allow them to have dual inheritance rights would give adopted children more rights and privileges than those possessed by a natural child. And so the thinking of the states as they evolved in their thinking was that shouldn't be the case, right? Now, the authors actually kind of disagree, and that it's a problem to inherit from both. They believe that the Maryland's, what they called in the case, their transplantation theory of adoption, that you're severed from your prior family tree and then connected to a new family tree, is a little overblown, okay? And so they give an example. Let's think about this for a second. So we have husband one and wife have a child. I'm missing my board space, so I apologize here. There's really no way to do this, okay, without going up and down. Okay, so let's do our best. I'll write on the wall. Husband and wife have a child, A, okay? But then they divorce. And if the wife is the custodial parent and then remarries husband 2, okay? And husband 2 adopts A, the authors think that A should be able to inherit from both H1 and H2. And you're like, okay, well, how does that work? Well, there's a little problem there that's called, parental rights. H2 is not going to be able to adopt A without H1 severing his parental rights with that child. Is everybody clear on that? That's kind of from family law, but provided that the genetic father, even though now divorced and non-custodial, is alive, he still has parental rights. It would require him either abdicating those rights or a court ruling that that relationship, that genetic relationship, has been severed. That might happen if perhaps, right, we're talking about a convicted murderer or some other completely unfit, maybe a neglect or abusive parent. H1's got to be cut out of their legal rights before H2 could adopt anyway. So in some ways, talking about, well, should there be dual adoption, dual inheritance rights is a little bit of a stretch, okay? But in kind of a typical adoption scenario, where you have natural parents, and for whatever reason, they decide to, sever their parental rights and allow the child to be adopted, there are some theories in place that say, well, what if this now adopted child is the only child from their genetic side of the family that can inherit? Okay, should we be looking at that? But for the most part, I think the consistent theme, as we're going to see, is that adoption severs the parental relationship with the genetic parents, and now the adopted child is considered to be the child of the adopted parents. Okay? What's going to get a little confusing is when we talk about these blended family situations, right? Where you have a situation where the first one of the parents has predeceased, and now we have a new a step-parent coming into place, and then the question becomes, does that sever, and there's going to be an exception, as we're going to look at, that doesn't affect the mother's parental relationship, but it will affect the relationship with now the deceased father's relatives. But we're going to look at those nuances as we go along. So states still kind of vary a little bit, okay? In light of diversity and the complexity of kind of modern families, the fact that we have different types of families with adoption, multiple marriages, single parents, unmarried domestic partners, states are kind of having to look at these issues a little bit again where they haven't looked at them for years. Okay? So we just talked about Maryland having no dual inheritance. But in Texas, for instance, it's still law that an adopted child can inherit from both adoptive and natural parents and their relatives. So in Texas, you could be adopted and still inherit